Senator Virginia.
Mr. President, I thank you and my colleagues for being on the verge of a vote on a matter I've placed before the Senate together with Senator Durbin, Senate Joint Resolution 190. I think Senator Durbin has already spoken, and I believe Senator Padilla will follow me, and then we will move to the vote. But I just want to explain why I think this is such an important matter. The resolution would repeal a regulation that the Trump administration has put in place concerning the appeal of immigration cases. So immigration cases, as we all know, that are heard in immigration courts by administrative law judges often involve very, very momentous matters for the applicants. And traditionally, immigration cases are able to be appealed to an appellate administrative process in case a judge gets something wrong. And the appellate process is designed in all court systems to enable the correction of error. No judge is infallible. Judges make mistakes. Sometimes judges make mistakes because the quality of the lawyering before the judge is not that good. But whether it's a civil matter or a criminal matter or an administrative matter, a real hallmark of the American legal system, and I think it's something we can be proud of, is there is an appeal process to correct mistakes. The regulation that President Trump's administration has put in place that I challenge in the resolution that will come up is a regulation that dramatically limits immigration appeals. So, for example, prior to the Trump regulation, somebody who got an immigration decision from an immigration court would have 30 days to appeal. The Trump administration regulation that I challenge has shrunk that amount of time to 10 days. What is the problem with that? Oftentimes, the immigration judge signals a ruling but hasn't even done a written opinion within 10 days, that an individual or lawyer could know whether there is a basis for appeal or not. And so the reduction of the time to appeal to 10 days is certainly going to have the consequence, and I think it's an intentional thing, to dramatically limit people's ability even to appeal. The absence of a record, the absence of a written decision would severely challenge somebody's ability to appeal. In some ways, Mr. President, the more serious concern I have about the regulation is it also gives the immigration judges a massive ability to summarily dismiss appeals without any hearing whatsoever. So even if you file your appeal within the 10 days, the new regulation allows the immigration court to summarily dismiss those appeals 10 days later, unless a majority of the appellate body wants to hear the case. And so there's almost a default that the appeals will be summarily dismissed. And again, if you look at the time deadline, 10 days to file the appeal, and then you can summarily dismiss within 10 days, a total of 20 days. Again, you may not even have a transcribed court record from the immigration hearing or a written opinion from the immigration judge by the end of that 20-day period. And so this is an effort to essentially make the appeals process meaningless by imposing such tight time deadlines on the filing of appeal and encouraging the dismissal of appeals on a summary basis as to render the appeals process completely unworkable. All right, what does that mean? Let's talk about what this means to immigrants in immigration courts. And Mr. President, I want to use two kinds of cases that are really common in the everyday work of our immigration courts. The first is asylum cases. The United States has had a practice, and other nations have it as well. And again, it's a practice that I think we should feel proud of, that we will offer asylum to individuals who are able to prove that they have a well-justified fear of persecution if they are returned to their country of origin. And this has been used to protect people from torture, protect people from imprisonment, protect people from death, protect people from all kinds of grievous harms in their countries of origin because they're a political opponent, because they're a member of a religious minority or an ethnic minority, because they've been subjected to domestic violence, because they've been pressed into service in the military as a child soldier in countries that force people into the military at a young age. And the U.S., along with nations around the world, has always allowed someone to come in and make this case. I will be subject to persecution, even to torture and death if you send me home. And the U.S. has allowed people to make that case. And my belief is that's a good thing, not a bad thing. Maybe the standard should be a tough standard, but if you meet that standard, you should be allowed to remain here rather than be sent back to suffer horrible consequences in the country where you come from. Mr. President, let me give you a couple of examples of this that are sort of topical and recent examples. President Trump authorized military action in Nigeria on Christmas Day to bomb certain areas and target certain groups that were persecuting Christians. Christians being persecuted in this part of Nigeria led the president to say, this justifies the use of the U.S. military to try to eliminate the threat whereby people practicing their Christian faith will be targeted for torture and even death. So the president has acknowledged that this is a serious concern. And so what if somebody from Nigeria seeks asylum status in the United States and says, I'm a Christian. I'm being targeted because of my religion. President Trump believes this is such a serious thing that he authorized U.S. military action to target terrorist groups in Nigeria to protect Christians. I would like asylum status in the United States based on President Trump's recognition that I'm subject to religious persecution. If you force essentially the evisceration of an appeals process, you run the risk that individuals who are subject to persecution of this kind would be returned home and thereby face the very persecution that President Trump has spoken out against. Here's another one, Iran. Iran's regime is one of the grossest violators of human rights on the planet, to political opponents, to religious minorities. There are Iranians in the United States right now who have active asylum cases and are attempting to demonstrate, please don't send me back. The work that I've done in Iran against the regime will immediately get me imprisoned or worse should I be sent home. And so if you're going to have a protection for asylees, if you're going to say we don't want to send people back to a place where they're going to be tortured or killed for an illegitimate reason, you shouldn't turn the immigration appeals process into essentially a worthless process that does not provide protection for people who have a high risk of suffering if we make a mistake in an immigration case. So that's one kind of case, and an asylum case is a standard everyday case in our immigration courts. And I think there's a pretty strong motive that we not make mistakes in these cases, but we get them right. And an appeals process that is substantive and significant increases the chance that we'll make the right decision, and eliminating the appeals process or dramatically reducing it increases the chance that we'll make a mistake. Second kind of case, Mr. President, that is also just the everyday case, whether somebody, because of their immigration status, will be deported. Those cases are happening as we're speaking right now in immigration courts all over the country. Now, the cases tend to turn on, a legal question about somebody's immigration status and whether they're subject to deportation because of their status. But Mr. President, at the base of this case, there's a legal issue, but most of these cases, the real issue is family separation. Will we separate children who were born in the United States from parents who came here in an undocumented status? Almost all of these cases about deportation involve families, and almost all of them involve families that have mixed status. Some might be U.S. citizens, some might be green card holders who are seeking to be citizens, some might have humanitarian parole, some might be special immigrant visa status, and some are undocumented. And so while a case in an immigration court might seem like it's about a code provision, the human issue in the case is whether we maintain a family together or whether we force a family to separate. And there is not a more significant issue ever litigated in any court in this country than that. My wife, Ann, and I've talked about her probably too much on the Senate floor because I'm so proud of her, but one of the chapters of her professional life was she was a juvenile court judge in the Richmond Juvenile and Domestic Relations Court for 9 years, and for the last 3 years, she was the chief judge of the court. Now, the work, Mr. President, I know you know this, of a juvenile court judge is really tough because you're dealing with the worst things that people do to each other. You're dealing with child abuse cases. You're dealing with kids who are the victims of horrible crimes, and sadly, kids who commit horrible crimes. The number of times my wife had to preside over murder cases, again, somebody murdered or a young person who commits a murder, grim stories, and she would come home in a bad mood because of that case. But the worst cases my wife ever had to preside over were not the murder cases. They were not the child abuse cases. My wife said the hardest cases for a juvenile and domestic relations court are cases involving the termination of parental rights. The parent has had a child. That parent might have been sentenced to prison. The parent might have an addiction issue. The parent might have had neglect issues or might have had serial abuse. And maybe the parent did a whole lot of bad things to this child. And now there's a legal proceeding before the Juvenile and Domestic Relations Court. Will the parent's right be terminated forever? I mean, it's a forever decision. It's a decision about family separation. And my wife would come home from those cases and say, these cases are tougher than the murder cases. They're tougher than the child abuse cases. When you're sitting as a judge and you're looking across the dais at somebody, and the question that you have to decide is, will I terminate this mother, terminate this father's right to be the parent of this child forever? Those were the toughest cases. The toughest cases. That's what these immigration cases are. They're cases about a provision of the immigration code, but the consequence is family separation. In the instance of a deportation, it might be family separation forever. My wife would say, though, I hate these cases, but thank God there's an appeal. In the Virginia system, a decision about a termination of parental rights could be appealed up to the circuit court. And she used to say, I'm a smart judge. I listen real carefully. I try to decide right, but I'm not an infallible one. I might make a mistake. And the fact that there is an appeal that is essentially an appeal of right, that the individual can immediately file an appeal, and that appeal has to be heard in the circuit court, that gave her a little bit of comfort that if I make a mistake, there can be somebody who can correct the mistake and not terminate somebody's rights to be a parent for the rest of their life over their own child. That's what these immigration cases are. In fact, I think even a higher percentage than dealing with asylum status are cases about deportation of people over their legal status. And in almost every one of those cases, it's really a case at root about family separation. And it just strikes me that when the stakes are that high, and if we acknowledge our own infallibility as legislators and as judges, having an appeals process that's meaningful isn't a bad thing. It's not something we should try to eliminate. It's something we should actually celebrate and say it's a hallmark of our system. And so for that reason, following my colleague, Senator Padilla, who I know is going to come and speak on this matter, I will call up at the appropriate time this resolution and ask my colleagues to stand for the broader proposition that our justice system in this country is not perfect, and it's never going to be. But because it's not perfect and because we're not perfect, we have an appellate process that provides some kind of a check against mistakes, and that is something to celebrate, not to eliminate. And that's the purpose for the bill that I'll bring before the body following Senator Padilla's comments. And with that, Mr. President, I yield the floor.